Well, good afternoon, Michiganders. It is Tuesday, September 6th, 2022. Let me say that again, September 6th. How can it be September already? It seems just a week ago it was June, and now we're quickly approaching fall. But of course, this is, as always, Tuesday with Tom, Michigan's only weekly internet show where we do answer your questions about estate planning and estate settlement in Michigan, and we don't send you a bill. I'm your host, Tom Doyle, estate planning attorney, lifelong Michigan resident, and ambassador for all things good in the state of Michigan. Welcome to today's program. Well, some news that I want to share with you today on September 6th as of September 1st, last week, we are now providing a discount on our estate planning and estate settlement services to Michigan Farm Bureau members. So if you're a Michigan Farm Bureau member, now one of your member benefits is a discount on our already reasonably priced estate planning and estate settlement services. So if that's something that you're interested in, you can find the discount on the newly revised Michigan Farm Bureau website under your member benefits section. Last episode was older Americans may be better off staying unmarried. And I talked about, generally I'm not one to discourage people from not getting remarried, but I did talk about some of the concerns that you need to address if you're an older American thinking about getting remarried. Well, today's show, I'm going to talk a little bit about real estate in today's show. In fact, in particular, we're talking about what is known as a property transfer affidavit. And so I'm going to explore with you this afternoon why you should file a property transfer affidavit with your deed. But please remember, what I'm about to discuss during the program is, as always, for educational purposes only. It is not intended to be specific legal advice for you. You need to work with your attorney to determine what is appropriate for you and your estate plan. Why you should file a property transfer affidavit with your deed. Well, let's start out with what is the property transfer affidavit and why are they even something that you might consider doing. Well, you might recall a couple decades ago now, Michigan passed an amendment to its constitution that basically put a cap on property taxes, or at least on assessments that affected property taxes until property is transferred. The reason for that back at that time is there were growing concerns in a number of communities where property values were skyrocketing, and a lot of the local people, it was perhaps skyrocketing because it had become a tourist destination, and then the local folks were finding their taxes going up and up and up and up every year, and so Michigan voters at that time adopted a constitution provision that basically was intended to cap the assessment on property taxes until the property is transferred. So the idea, and we talk about with this clients all the time, if you're looking at transferring your home or transferring a cottage or transferring any other real estate in Michigan, always need to be mindful of uncapping property taxes. The same thing goes for when you buy it. A lot of people don't stop and think that they buy property and they're going to have a mortgage on it, and the mortgage is going to have provisions for you to be paying property taxes on a monthly basis. That's normally based upon the past assessed value of the property, which is likely going to certainly change if you're now paying for that property more than what was the assessed value on the property. So your taxes are, at some point in time, going to be going up. Now, so in Michigan, when there's a transfer of the real estate, and quite frankly, when there's a transfer of certain types of personal property even, when we're talking about real estate today, we need to look at whether or not you're going to file a property transfer affidavit. That becomes important for this reason. If your transfer is exempt from being reassessed, meaning if there are reasons under the statute, because these particular statutes involved, set forth a number of types of transfers that are exempt from uncapping. So if your transfer is a transfer that's going to be exempt from uncapping, you certainly want to make sure that you're filing your property transfer affidavit with the assessor's office at the time that you record your deed. Why? According to the law, what is supposed to happen is, I believe it's monthly or bi-monthly, don't hold me to the time frame, but what's supposed to happen is every registered deeds office at a certain period of time, again, monthly, bi-monthly, whatever it is supposed to report to the assessor's office any deeds that had been recorded that would be considered a transfer of real estate. So if you go ahead and record your deed and you don't notify the assessor's office that it's an exempt from uncapping, what's going to happen is at some point registered deeds office is going to notify the assessor's office that property's been transferred. And absent a property transfer affidavit, which is the form that the state provides, the assessor is going to look at that and say, hey, there's been a transfer of this property. I, the assessor, have not been provided with any information that says it's exempt from uncapping. And so, more likely than not, they are going to uncap your property taxes, even if, under the statute, it would be exempt from uncapping. It's not their job to go and look at the deed and contact you and find out, is this an exempt from uncapping or not? That's your job to do, and when you are purchasing that real estate. So that's what's going to happen, and then you're going to have a fight with the assessor's office. You're going to want to provide information that really is exempt, et cetera, et cetera. The other consideration, though, although it's not perhaps something that's going to cause tremendous harm, but if you don't, according to the statute, you are to file the property transfer affidavit within 45 days of the transfer. Now, the transfer doesn't just occur when you record the deed. Technically, the transfer occurs the moment that you sign your deed. So 45 days after you execute your deed, you are supposed to file the property transfer affidavit with the assessor's office. If you don't, there are penalty provisions in the statute. And there's a fine that can be assessed against you under the statute for every day that goes forward where you're not filing with the assessor's office an appropriate property transfer affidavit. So even if you're exempt from uncapping, but you haven't filed the property transfer affidavit, you can be running in a situation in which you're going to be assessed a fine. Now, it maxes out generally at $200. So a lot of clients are going to sit there and say, oh, I'm not going to worry about the $200, but you need to understand there is a provision in the statute for an assessor, if you will, to assess a fine of that $200. But more important, let's go back. So let's say you're transferring this property and you think it's exempt. Well, let's talk about a number of the common exemptions. These would be, even though it's legally a transfer, it's a transfer that's exempt from uncapping. So a number of those. One, and if you just look at the property transfer affidavit, you're going to find the most common exemption, not all of the exemptions, but you're going to find the most common exemptions are listed on the form. Of course, there's another place on the form to put other exemptions. These would be exemptions under the statute that haven't been carried over into the form. But first one, transfer from one spouse to another. So you're going to transfer your real estate from yourself to your spouse. That is not an uncapping event. Also, beginning in 2014, transfers to a spouse's mother or father or brother or sister or son or daughter or adopted son or adopted daughter or grandson, granddaughter, etc., those also are not uncapping events. Another one, change in ownership solely to exclude or include a spouse. So maybe you've gotten married and you're going to add your spouse to the title. Or maybe you've gotten divorced, okay, and now you're going to remove a spouse from your title. Those are not uncapping event. And again, transfers between certain family members. It's not just, spouse to others. It simply transfers between mothers, fathers, brothers, sisters, sons, daughters, adopted son, grandson, granddaughters, etc. Those are all examples of transfers that are exempt. A major one, and it's one that our office is dealing with all the time. Let's say that you have had a living trust created for you as part of your estate plan, and now you're going to put that real estate into that trust. So you're having a deed prepared. Well, there is an exemption, a specific exemption, if it's a transfer into a trust where the settlor, that's the person who creates the trust, or the settler's spouse conveys property to the trust and is also the sole beneficiary of the trust. And that's normal with the living trust that's created for you. You and or your spouse are normally the sole beneficiaries of the trust at the beginning. And so the transfer into that trust where the spouse or the settler or the settler's spouse is a sole beneficiary, that's an exemption. That's also going to be an exemption if you're using a ladybird deed, which is commonly used today. It's certainly something we're using in our office very frequently when we're looking at transferring that real estate into that trust. Now, I'm not going to go in today necessarily why you use a ladybird deed. I've had other episodes about that. But there are certain considerations that Amanda and I look at that cause us to prefer using what we would call a ladybird deed to transfer that property into the trust. That's also an exempt transfer. There's a specific exemption for that portion of property that is subject to a life lease or life estate until the life lease or life estate expires, which is essentially what really a ladybird deed does. It creates a life estate, and you keep the life estate, and then the property transfers into the trust at your death. Now, if you look at that, many of the assessor's office would look at that and say, hey, now we have to talk about 2 times that a property transfer affidavit needs to be filed. First, when you create the ladybird deed, because that's an exemption because there's a life lease or a life estate. Then, when you die and now that property goes into the trust, that's also a transfer. So they would argue that a property transfer affidavit needs to be prepared up front and a property transfer affidavit needs to be prepared when you die. And then, if the property is going to be transferred out of the trust to a child or a grandchild, to any of the individuals designated in the statute, that would also be an exempt transfer, but a property transfer affidavit would need to be filed. Again, the reason you want to make sure that that property transfer affidavit is filed with the assessor's office is because you and or your heirs don't want to end up in an argument with the assessor's office who's come out in uncapped property taxes and now is in a dispute with the owners about what do they have to do to undo that. Another consideration when you fill out the property transfer affidavit, and this comes from experience, they're going to ask you for the address of the property, the county, the PIN number, that's the special number, property identification number that is relative to the property. And they're going to ask you for the seller's information, the buyer's name and mailing address. And one of the things you always need to be mindful of is whatever you put in there as the buyer's name and mailing address, that's where your property tax statements are now going to go. So let's say, for an example, that you're doing a ladybird deed. You don't have a trust, but you're doing a ladybird deed that's going to transfer property to a child upon your death. If you put the child in there as the buyer, what's going to happen is the assessor is going to begin sending the property tax bill to your child. Well, if it's a ladybird deed, it's exempt because it's transferring that portion subject to a life estate and until life estate expires. So really you are both the seller and the buyer at that, but you're transferring it from you as a owner and you're transferring the life estate to you as the buyer. And so what we normally do is we're just going to put your name and address in there so that you keep getting the tax bills appropriate, and then you're not worry about whether or not your child is going to provide that information to you. And I think there's a logic to doing it that way because it's not going to be the child's property until you die, so why do you want them to be receiving your property transfer affidavit? Another important one for a number of our clients that have qualified agricultural property, transfer of qualified agricultural property is exempt if it's going to remain qualified agricultural property and the agricultural property affidavit has been filed. So now you've got two documents that you're going to have to file when you're looking at doing that transfer. One is going to be the property transfer affidavit, but the other one is going to be the appropriate agricultural property affidavit that needs to be filed as well. So you have to do both of those in order for it not to become uncapped. Again, the property transfer affidavit, you can find it online at michigan.gov. And the form can be filled out and sent into your assessor's office. If you're looking at transferring property, I encourage you to take a look at the property transfer affidavit. See if your transfer is one of those transfers that exempt from uncapping. And if it's not specifically listed in that document, it might be also helpful for you to go and look what the state of Michigan has put together on property transfer affidavit. There's by the Michigan State Tax Commission, a document that's called Transfer of Ownership Guidelines. It was issued back, I believe, in 2017. That's the document that essentially lists all the different exemptions, even if they're not listed on the form. So you might have an exemption, for example, if that property is now going to come out of the trust to a child, that's not an uncapping event, but there isn't a provision on the form for that. So something like that, you would be writing in the other and specifying why it is exempt from the uncapping. So it can be very important to you, particular when we've looked at most recently significant increase in values of real estate, and you just don't want to be stuck at an argument with your assessor's office when you had something that was exempt, but you didn't notify them that was exempt, and now you're going to be stuck with the property taxes. One transfer to keep in mind, too, that is not exempt, that a lot of people sometimes don't realize, a transfer into a limited liability company is not currently exempt in the state of Michigan. Sometimes we're dealing with clients who might have thought, well, geez, why don't I take my cottage that has been in the family for a long time and we're going to transfer that cottage into a limited liability company because that's what we're going to use as a tool to keep the cottage in the family, you simply need to be mindful of that is not an exempt from uncapping. So in order to accomplish that, transferring to the limited liability company, you're going to have to be dealing with uncapping property taxes. So it's something, if you're looking at doing, you need to give some consideration of other alternatives that might be available to you if uncapping the property taxes is going to be of concern to you. Of course, Amanda and I would be happy to talk to you about your concerns about uncapping your property. Normally, as part of our process when we're doing deeds today, we're including the Property Transfer Affidavit to make sure that that is being made available for the client. And of course, too, we would be honored to have the opportunity to help you protect your loved ones by putting together your estate plan or amending a current plan or assisting you in settling a loved one's estate. Simply head on over to the website, that's doylawpc.com, and check on the virtual office. Now, from the website, a couple episodes ago, I did a tour of the website. But if you go to the website, you're going to find links for scheduling consultations. You're going to find links for sending us documents that we're going to need. You're going to find copies of our estate planning guidebook. So if you're a prospective client, and you're going to the virtual office section at Doyle Law PC, you're going to find the ability to schedule a consultation. You're going to find information about how do we actually prepare an estate plan for you by using Zoom or telephone consultations, and the ability to download our estate planning guidebook that's free. If you're a current client, not only can you schedule a consultation, but we do offer current clients through the virtual office at what we call our Update My Plan service. You fill out a form, tell us what changes you're looking at making, and we'll get back to you on what it's going to take to make those changes, what documents need to be updated to make those changes, and we might be able to do all that without even the need for a consultation. Of course, too, if you have individual documents that you're looking for, maybe all you need is a certificate of trust because you've got a trust that's selling real estate, or all you need is a durable power of attorney, I invite you to check out the legal store, the tab that's on the website, doylawpc.com, and there you're going to find a number of individual documents that you can order online as well. Well, that's going to be it for today. Again, September 6th. I guess I have to get over that, but that's it for today's show. As always, though, if you have a comment about the program, a topic that you'd like to discuss, or questions that you'd like to have answered, please send me an email. That's tom@tuesdaywithtom.com. You can mail me a postcard, Tom Doyle, P.O. Box 3752, because we're now in Grand Rapids. So it's P.O. Box 3752, Grand Rapids, Michigan, 49501. Please, too, follow us on Facebook and Twitter. That would be Tuesday with Tom. Follow the office as well at Doyle Law PC. And, of course, please invite your friends and family to follow us on Facebook and Twitter as well. And don't forget, if you have a smart speaker, you can always ask your smart speaker to play Tuesday with Tom. And you will likely find the program available anywhere that you normally listen to podcasts, such as Apple Podcasts, Spotify, Google Podcast, iHeartRadio, Spreaker, etc. Well, thank you again for spending some of your time with us today. And as always, I hope that you have an awesome day and an awesome week in Michigan. Stay safe. Tuesday with Tom has been brought to you by the estate planning attorneys at Doyle Law PC. To learn how we can help you with your estate plan or with settling a loved one's estate, please call us today at 517-323-7366. That's 517-323-7366.